Good afternoon, everyone. I declare open today's meeting. Welcome to meeting number 91 of the House of Commons Standing Committee on Industry and Technology. Today's meeting is taking place in hybrid format pursuant to the standing orders. Pursuant to the order of reference on Monday, April 24, 2023, the committee is resuming consideration of Bill C-27, an act to enact the Consumer Privacy Protection Act, the Personal Information and Data Protection Tribunal Act, and the Artificial Intelligence and Data Act, and to make consequential and related amendments to other acts. I would like to welcome our witnesses here. Appearing as individuals, we have David Fraser, partner, McInnes Cooper, Eloise Graton, partner and national leader, Privacy and Data Protection at BLG. She was also my teacher at the University of Montreal for a while, so it's a pleasure to see you. We also have Daniel Terrien, lawyer and former Privacy Commissioner of Canada. Welcome here, Mr. Terrien. And from the Canadian Anonymization Network, Adam Kadash, partner, Khaled El Emam, professor by video conference. Since we have a great panel with us today to continue consideration of this Bill C-27, I'll give the floor to Mr. Fraser for 5 minutes.
And thank you for your kind invitation to appear before this committee to assist in its important study of Bill C-27. I'm a partner in private practice at a law firm where I've been practicing privacy law for 22 years. Most of my practice involves advising international businesses on having to comply with Canadian privacy laws, and more often than not, they're trying to make their existing privacy programs that they've developed in places like Europe and California work in Canada. I also advise Canadian businesses, large and small, in compliance with these laws, and regularly advise organizations in connection with investigations and encounters with the Office of the Privacy Commissioner of Canada and his provincial counterparts. I'm here in my own personal capacity, but obviously my work and opinions are informed by my experience working with my clients. Now, I may come across as somewhat contrarian in saying this, but I actually think that PIPEDA works pretty well as it is. It was designed to be technologically neutral, is based on existing principles that are largely embedded in Bill C-27, and one thing I've often said is C-27 takes PIPEDA and turns it up to 11. I don't think the legislation is necessarily broken, and I do think that the Commissioner has, over the past 22 years, not necessarily exhausted all of his enforcement powers and authorities over that time. I'd like to start by saying that I don't really like the name of the new statute. Canadians aren't simply consumers. This legislation applies to consumers. It also applies to certain employees in the federally regulated sector. It's a little bit negative and dismissive. If we're wedded to the acronym CPPA, we could call it the Canadian Privacy Protection Act, but I don't think that actually affects its substance. Now, I like PIPEDA, but over the last little while, it's pretty clear that there's an emerging consensus looking towards order-making powers and penalties, thinking that they're desirable. And in the course of doing this, I would ask the committee to consider that requires a commensurate and appropriate increase and shift for greater procedural fairness, and that would be more than is currently in the bill. I'm of the view, based on my experience, that the Privacy Commissioner has a bit of a conflict, or potentially a conflict, in being a privacy advocate, privacy educator, privacy police, privacy judge, and privacy executioner. Any determination of whether a violation of the CPPA has taken place and what penalties should be imposed should be carried out by an independent arm's-length tribunal, such as the federal court or such as the new tribunal. The Commissioner can recommend a penalty and can take the role of the prosecutor, but ultimately the determination of whether or not a violation has taken place and whether or not a penalty should be imposed should be vested in an arm's-length body. I think the recent Facebook case in the federal court is a bit of a cautionary tale, and I'd be happy to talk more about that. Children's privacy is obviously a very important theme in this particular piece of legislation, and I agree and appreciate the views of the government and the Commissioner with respect to protecting the privacy of children. One thing that I'm a little bit concerned about is that the current bill would be difficult to operationalize for businesses that operate across Canada. Whether or not somebody is a minor currently depends upon provincial law, so that varies from province to province, and implementing consistent programs across the country, that would be difficult. I would advocate for putting in the legislation that a minor is 18 years or below. I would also suggest that there should be a presumption that children under the age of 13 are not able to make their own privacy decisions, and their parents should be their substitute decision makers by default. And for organizations that have a general service to the public, like a car dealership, for example, there should be a presumption that all their customers are adults unless they know otherwise. So if you have a website that's focused towards children, you know that there are children in the audience, you have to calibrate your practices appropriately. Anything different might lead to mandatory age verification, which can be very difficult and raises its own issues. Having been involved in investigations and also having been involved in litigation involving privacy claims, I would suggest that the private right of action should be amended to be limited to the Federal Court of Canada. If you're wedded to a private right of action to begin with. The problem is with the existing legislation, anybody can go to the Federal Court of Canada or to a provincial court. And we know that there are going to be hundreds of people affected over the next decade or so with respect to particular incidents. And so you're going to end up with duplicative proceedings simultaneously across the country, which we already know that judicial resources are significantly taxed. I think legitimate purposes, which is largely based on the European model, needs to be more closely aligned, and I'm happy to provide more details with what is happening in Europe. And with respect to the Artificial Intelligence and Data Act, it should be its own statute, its own bill, subject to its own study. But I would note that excluding government from it is dangerous. Government has guns. Government decides about it benefits, immigration, things like that. I think it's subject to a constitutional challenge. It's not necessarily harmonized with what's going on with their international trading partners, and there should be reciprocal recognition. If a company is complying with European data regulation, we have deemed it to be substantially similar, that should work. Otherwise, we're going to have difficulty with Canadian businesses operating internationally and international businesses coming here. And finally, I think research and development should be removed from the bill because it presents no real risk of harm to an individual until it's presented into the public. I have a longer list. I could go on for much more than 5 minutes, but I think that's my time, and I look forward to the discussion.
Thank you very much, Mr. Fraser. I'll now turn to Madame Gratton for 5 minutes.
Alors, merci de l'invitation.
Thank you for inviting me. I'm happy to be here and to have the opportunity to share my reflections on Bill C-27. I'm a partner and in charge of privacy and data protection. I've been working in this domain for more than 20 years, and I've worked with lots of national companies, and sometimes they have operations abroad. I've also had the opportunity to see how this act has evolved in Europe over the past few years. So within the framework of these reforms, we have lessons to draw from Quebec and from Europe. So it's in that individual capacity that I'm appearing here before you. I will be testifying in English, but I'll answer your questions in French or English.
Importance, the reform of our privacy, federal privacy law. We find ourselves at a critical juncture where we have the unique opportunity to strike a balance to ensure that the protection of our privacy rights while fostering an environment of innovation. So in a rapidly evolving digital age where information flows faster than ever before, our privacy is at an increased risk. So this makes it imperative that we reform our privacy laws to reflect the realities of today. However, data protection laws should not stifle the innovation spirit that has propelled us into the 21st century. So Canada needs to remain competitive. Innovation drives economic growth, creates jobs, improves our quality of life. So it's the engine of progress. So striking the right balance between privacy and innovation is a complex task, but I don't think it's an impossible one. So I'll focus my presentation on the Consumer Privacy Protection Act in areas of improvement on 4 specific issues potentially impacting innovation. So first, I absolutely welcome the introduction of a consent exception regarding specified business activities and for certain activities in which the organization has a legitimate interest under 18.3. This being said, the legitimate interest exception is actually narrower than the same exception under the GDPR. So David raised this issue, so I'm gonna talk a bit more about it. C-27 provides no exception nor any significant flexibility as to the application of the consent rule to the collection of personal information collected from publicly available sources on the internet. So it prevents all organizations, including legitimate ones working on new products and services that may benefit the society, that need a large volume of information to actually leverage data available on the web. So in short, I submit to you that this legitimate interest exception should be more closely aligned with the GDPR legitimate interest legal basis to accommodate innovative types of business models while protecting the privacy interests of Canadians. Section 39 creates a new consent exception for disclosures of de-identified personal information to specific public sector entities, including government, healthcare, post-secondary educational institution. Limiting this consent exception only to disclosures to public sector entities instead of public and private sector entities severely restricts its utility. So Section 39 should authorize and facilitate responsible data sharing amongst between a broader range of actors, which may have access to talent and resources that they can leverage, to pursue socially beneficial purpose. The CPPA, third point is the CPPA introduces a new definition for the terms anonymized and de-identified, provides greater flexibility regarding the processing of these categories of information. However, the proposed standard for anonymization under Section 2.1 is more stringent than other recently updated privacy legislation, including the GDPR and the recently amended Quebec Private Sector Act. So my point is that the CPPA should include a reasonableness standard instead of holding organization accountable to an absolute standard that may be impossible to meet in practice. As you certainly know, access to anonymized data sets with legal certainty is crucial to research and development performed by Canadian organizations. And I have a feeling that Adam Kardash and Khaled Elmaman will be talking about this a bit more. So my last point is that Section 21 introduces a new consent exception for the use of de-identified information for internal research, analysis, and development purposes. Restriction, this use to internal uses may limit the collaboration and the fostering of research partnerships, preventing stakeholders to share data sets to create data pools that are broad enough for the production of useful and actionable insights. So this section should authorize the use and sharing of de-identified information amongst different organizations. I've submitted a short brief in French and English in which I provide additional details on these 4 proposed changes. I think that innovation and privacy can coexist, and the responsible use of personal information can be the cornerstone of building new and exciting technologies while respecting our fundamental rights. So thank you, and I welcome questions.
Merci beaucoup, Madame Gratton. Je passe.
Thank you very much, Madame Gratton. Now, Mr. Thérien, you have 5 minutes. Thank you very much, Mr. Chair, and thank you, members of the committee, for the invitation to participate in your study. I'm here in my personal capacity, but I used to be a privacy commissioner from 2014 to 2022, and that certainly informs my comments. Right away, I agree with my successor, Philippe Dufresne, that the bill before you is a step in the right direction, but it is necessary to go further in order to properly protect Canadians. I also agree with the OPC's 15 recommendations for amending Bill C-27 with some nuances on audits, remedies, and appeals. The government has taken up, at least in part, a good number of the recommendations I made regarding Bill C-11. Some were not taken into account, for example, the ones that have to do with political parties. I am happy that there seems to be consensus between the parties to recognize privacy as a fundamental right. The principle has been established. How do we integrate it effectively in the legislation? Minister Champagne suggests amending the preamble.
But they are not sufficient. You should also amend 2 operative clauses, Section 12 of the Act on appropriate purposes, and Section 94, which provides for administrative monetary penalties for certain violations of the law. Without these amendments, the law would still give greater weight to commercial interests than to privacy, a fundamental right. This does not appear to be your intent. Based on my reading of parliamentary debates, it also seems to me there is consensus around the idea that privacy and economic growth through innovation are not in a zero-sum game. The question is generally not to decide which should prevail as between privacy protection and innovation. Both can and should be pursued at the same time. It is only in rare cases that this will not be possible, and in those cases, privacy as a fundamental right should take precedence. Section 12 of the CPPA does not, in my view, faithfully translate this consensus. It rather upholds the traditional approach under which privacy and economic goals are conflicting interests that must be balanced without considering that privacy is a fundamental right. This may have made sense under the current Act's Purpose Clause. It would no longer make sense if the CPPA's Purpose Clause does recognize privacy as a fundamental right, as is currently proposed. Section 12 is central to the exercise that commercial organizations, the Privacy Commissioner, and ultimately the courts will have to go through to determine, having regard to the factual context of each case, the weight to be given to privacy and commercial interests. Cet article donne plus de poids aux intérêts économiques.
This section gives more weight to economic interests in many ways. First, through the terminology. It refers to business needs and does not refer to privacy as a right, as a fundamental right, or as a right at all. When it does refer to privacy in paragraphs 2D and E, it is an element to consider in achieving business goals where possible, where achieving business goals can be achieved, and allowing the business to obtain gains. Nowhere is it said that we must consider violation of privacy as an element that is just as important as the pursuit of business interests. To the contrary, focus is put on business activities, whereas privacy is something that should be taken into account. In the annex, you have notes amending S12 and translating, hopefully, your intent to recognize privacy as a fundamental right. When it comes to sanctions, without sanctions, recognizing privacy as a fundamental right would be a pious wish without real consequences. Furthermore, in my opinion, any violation of the law should be penalized, and is the case in many other countries.
AI and Data Act. That part of Bill C-27 is brief, even skeletal, and leaves a lot of room for regulations. While I understand why some are concerned with this, I think this approach is defensible, given the fact that AI technology is relatively nascent and is certainly evolving very quickly. However, the lack of precision in AIDA, in my opinion, requires that certain fundamental principles and values be recognized in the Act itself. First and foremost, the Act should recognize the importance of protecting fundamental rights, including the right to privacy, in the development and implementation of AI systems. Finally, some of you have expressed concerns in an earlier meeting with the difficulty of detecting violations of the law and the potential value of proactive audits to facilitate detection. As Commissioner, I had recommended proactive audits, and I still believe they are a necessary part of an effective enforcement regime. This is particularly true in the case of AI. Thank you, and I would be pleased to take your questions later.
Thank you very much, Mr. Terrien. And finally, from the Canadian Anonymization Network, Mr. Kardash.
Thank you. Good afternoon, everyone. My name is Adam Kardash. I'm chair of Osler, Hoskin, and Harcourt's National Privacy Law and Data Management Practice, and have been practicing exclusively in the privacy area for more than 20 years. I'm pleased to be before INDU on behalf of the Canadian Anonymization Network, which is a not-for-profit organization whose members comprise large data custodians from across the public, private, and health sectors. I'm joined this afternoon with Khaled El-Imam, Canada Research Chair in Medical AI at the University in Ottawa and a leading global expert on anonymization and de-identification technologies and methods. As you are aware, Bill C-27 introduces definitions of anonymized data and de-identified data within the text of the proposed Consumer Privacy Protection Act. The concept of anonymized data is a core feature of the CPPA as it clarifies the scope of application of the CPPA's privacy legislative scheme. There are several very important provisions throughout the CPPA related to the terms de-identification and anonymization. It is therefore essential that the CPPA provisions relating to these terms, anonymized and de-identified data, be carefully considered and appropriately articulated within the CPPA's legislative scheme. In August 2022, Canon struck a working group to conduct a thorough legal consideration of Bill C-27, and we received comments from stakeholders across all sectors as part of a consultation process, including a workshop attended by over 100 participants. Canon is proposing surgical revisions that provide critical clarifications to several provisions with the CPPA, including to the provision referenced by my colleague, Ms. Eloise Graton, Section 39. We're proposing additional privacy protections to disclosures without consent for socially beneficial purposes. The details of our submissions are contained within a written submission we submitted to INDU. Our most important recommendation relates to the CPPA's current definition of anonymize. The current definition provides that personal information would be anonymized only if it is irreversibly and permanently modified in accordance with generally accepted best practices to ensure that no individual can be identified from the information, whether directly or indirectly. We're proposing an amendment. It's a surgical addition to this definition, as the current text of the definition of anonymized sets an extremely high and practically unworkable threshold for the circumstances in which information would no longer be deemed to be identifiable. Specifically, anonymized data within the CPPA does not incorporate the concept of reasonably foreseeable risk in the circumstances, and therefore it's not consistent with the standard for anonymization within legislative schemes across the country, including Quebec's Law 25, Ontario's Personal Health Information Protection Act, and multiple other statutes cited in our submission. We have everyone. There's at least 12 we've cited in the statute for your consideration when you're reviewing our brief. To be clear, and this is critically important, there is a very high legal standard for anonymization right now in Law 25, under PHIPAA, under all these other statutory frameworks. It's very high. But unlike the CPPA, the anonymization standard in these other legislative schemes is practically workable. And the reason for that is because it contemplates expressly contextual risk. As a result of these concerns, Canada has proposed an amendment to the CPPA's definition of anonymized that simply incorporates the concept of reasonably foreseeable risk in the circumstances into the definition. Our proposed surgical amendment would align the CPA's concept of anonymized data and critically ensure the interoperability of the CPPA with other statutory, with the standard for anonymization within other legislative schemes across Canadian jurisdictions. And also, critically, our proposal is fully consistent with well-established Canadian jurisprudence on the scope of the concept of personal information, the sites for which we provide in our submission. I'm going to turn my comments over now to Khaled El Imam to conclude our introductory remarks.
Thank you, Adam. So I wanted to use my time today to highlight the practical importance of Canon's proposals to the definition of anonymize. My comments today are based on my experience with anonymization over the last 2 decades, both in the context of research and applications in practice. A core focus of my work has been on the anonymization of health data such that it can be used and disclosed for research purposes, which includes developing new treatments and devices to help patients. In my view, the CPPA's current definition of anonymized most often will not work well in practice when interpreted literally. It risks setting an unachievable standard that, in practice, is not necessary for good privacy protection. The text needs to reflect the realities that the outcome of anonymization is not absolute. It is well established among anonymization and de-identification experts that data anonymization is a process of risk management. This is a foundational element of the recently published ISO International Standard for Data De-Identification. Good contemporary practices, when implemented properly, can ensure that the re-identification risk is very small. Very small re-identification risk can be precisely defined and has been precisely defined by organizations such as Health Canada. Effective re-identification risk management involves using techniques and technology to modify data, as well as the implementation of appropriate administrative and technical controls. The combination of modified data that has been wrapped with appropriate administrative and technical controls ensures that the re-identification risk can be made very small. This concept of risk management will not ensure that the re-identification risk is zero or that anonymized data is absolutely irreversible. That is not a practical standard that can be met. This is why it's important to amend the current definition of the term anonymized, which currently implies zero risk. Our proposal supports the important and necessary requirement currently within the CPPA's definition that generally accepted best practices are followed during the process of anonymization. But the canon proposal adds the concept of reasonably foreseeable risk in the circumstances so that the definition is actually workable in practice. Based on my years developing and implementing anonymization methods and technology, on behalf of Canon, the implementation of Canon's proposals will enable more responsible use and disclosure of data compared to the current definition. We thank you in advance for your consideration. We would be pleased to answer any questions you may have.
Thank you very much, Professor. So we'll start the discussion. And colleagues, given that we've got an hour and a half and a lot of witnesses, I'll be stricter on time. So please look at me towards the end of your time. And I know Mr. Perkins. No, you don't. Not today. So Mr. Perkins, without further ado, for 6 minutes.
Thank you, Mr. Chair, and thank you, witnesses. My first series of questions are to Mr. Thierry. You were the Privacy Commissioner during the development of the replacement for the Privacy Act in the last Parliament, Bill C-11, and presumably in the run-up to the development of this. The current Privacy Commissioner was here last week and said that essentially he personally wasn't the commissioner that was consulted on it. And this is a critical bill because this is a complete replacement of the Privacy Act. It's not an amendment. So I'll start by asking you, in the development of C-11, was the Minister of Industry of the day, I believe it was Mr. Baines, did he consult with you before the bill was tabled in Parliament?
We had a couple of discussions with Mr. Baines and with Mr. Champagne, but we never saw the actual text of the bill, but there were discussions.
So, but Bill C-11 was tabled,
yeah,
and C-27 was tabled. Did either of those bills reflect the advice you gave them? Obviously not, since you've asked for a number of areas, but did they reflect the desire to have fundamental right included in the bill?
I characterize Bill C-11 as a step backwards. I think C-27 is a step forward, so some recommendations that I had made as commissioner were accepted, not all, and not some that are, I think, essential that
but I assume you made a recommendation of fundamental right both times.
Yes.
And they were ignored both times.
At that time,
and
yes.
Now, 18 months after the minister introduced this bill, this flawed and broken bill, he's finally admitted after all of this process that it's a broken bill and he has to amend it 8 times at fairly fundamental things. So I'll ask you on this issue of fundamental right, whether you believe that simply putting it in Section 5, which is the most important section of the bill, on a parallel, because it says supposedly in the bill, when the amendment gets tabled, it says protection of privacy as a fundamental right, and the right to an organization basically to use that data. So it appears to me in the privacy, or the Section 5, which is the thing that sets out the whole purpose of everything else in the bill, that it's treated, personal privacy is treated of equal importance to that of a commercial entity. Is that true?
The first point I'd make is that it is important that Section 5 speak to and qualify the right to privacy as fundamental. It has meaning. But you have to look at the whole of the purpose clause, the preamble first.
The preamble isn't in statute, though, once the bill's passed.
The Section 12, which actually is when the balancing exercise actually occurs on a case-by-case basis, and Section 94, the penalty provision, all of these as a whole need to reflect the idea that privacy is a fundamental right. At this point, with the amendments tabled by the minister, we're doing well with Section 2 and 5, but not 12 and 94.
Well, I would say 12, 15, and 18 are critical in the privacy part. I agree that ADA is a blank slate. We'll come to that at another time, hopefully today. But Section 12, which sets out the purpose, and Section 15, which says express consent, and then says it's okay to use implied consent in 15.5, and then Section 18, which says that a business has legitimate interest to use your data basically however they want, even if it harms the individual. To me, it places the emphasis when you take Section 5, but then add Section 12, 15, and 18 to it. It looks like big business is being protected in this and their right to use your data, even if it harms you. Do you not need to amend all of those sections, not just 5 and 12?
I think Section 15 on consent does need to be amended, and I speak to this in the document I left with you. On the concept of legitimate interest, I would give the following advice. This is a concept that exists in European law, which is considered to be the gold standard internationally. So I think it is possible to have a legitimate interest type of exception to consent, provided that the sum total of 2, 5, 12, and 94 actually do protect privacy as a fundamental right. There's no inconsistency between legitimate interest and considering privacy as a fundamental right.
But without that, because the minister is not proposing,
We have a problem.
Without that, we have a problem. Absolutely. I just like to ask Mr. Fraser, in the little bit of time I have left, you mentioned, and I think ADA is a problem because ADA actually doesn't set out a public policy framework, which is what legislation is supposed to do. It just says, trust us, we'll do it all in regulation. But you mentioned that it would be perhaps open to charter challenge, and I wonder if you could expand on why.
So the conclusion I draw on that is it's simply saying within the legislation or saying within the bill that it applies to artificial intelligence in connection with interprovincial activities. The federal parliament has very little jurisdiction, for example, over computer science researchers sitting at the University of Toronto. That's exclusively within provincial jurisdiction. So there are going to be scenarios in which federal jurisdiction may be triggered, but in the vast majority of situations when a small company in Nova Scotia or a small company in British Columbia decides to implement an artificial intelligence system, that's not within the competence of the federal parliament when they do it on that small scale. So there are going to be significant gaps with respect to where federal jurisdiction can apply and where provincial jurisdiction already applies.
You're out of time. Thank you, Mr. Perkins. I'll now turn to Madame Lapointe for 6 minutes.
Merci. Ma question, c'est pour...
Thank you. My question goes to Madame Graton. In your opinion, will this bill help Canada to align with international standards when it comes to privacy protection, particularly the general European legislation? I think it's acceptable given that it tries to balance organizations that collect personal information for legitimate reasons while protecting personal information. That being said, it doesn't go as far as the European legislation. The European legislation is a lot more stringent. You previously stated, when talking about the initial privacy laws in Canada, I believe you said 40 years later, the concept is still one of the most predominant theories when it comes to privacy protection and the foundation of privacy laws in the world, including our bill. The approach used is no longer realistic. People are overwhelmed with information requests that they cannot reasonably understand or process. So this is my question. Would this legislation help ensure the fact, so because of this law, privacy as a personal responsibility is no longer possible. The average individual can no longer totally protect their data and their personal lives. Could you tell us whether, in your opinion, the bill is sufficient to protect personal information and to force companies to suffer responsibility for violations? Yes. First of all, let me clarify that statement. Clearly, the entire concept of individuals who control their personal information as a concept for privacy is one that dates back to the early 60s. Clearly, things have changed since then. There's a lot of information. Business models are complex. There are partnerships. So making sure that privacy policies are so long and detailed to make sure that individuals have all the information. And because of that, people cannot take the time, of course, to read all that information. Everything has become so complex and it has become a great burden. Taking into account all that, I think it's worth trying to reduce consent. We are faced with situations that require consent by the individuals. And just as they did in Europe with their regulation, we can introduce other laws that could protect individuals. So in that sense, I believe the bill is clearly a step in the right direction with some exceptions when it comes to consent. Of course, we need to come up with other guardrails. For example, when it comes to exceptions of legitimate interest, the company has to document why they think what they are doing is acceptable. So there are protections. More work is being given to companies to make sure that they protect the rights of people and their penalties. So I think the motivation is to make sure that companies comply and that we have good businesses while making sure that penalties are enforced. So I believe that the penalties align with what we see in Europe. So I think the incentives are present in this bill. Lastly, could you tell us what you think about measures in C27 that plan to protect personal data? Are you talking about security or safety? We don't have a lot of change. The clause that deals with safety protections is still neutral, technologically speaking. The current standards of the day are respected. Those of us who are lawyers in this domain will have to rely on decisions from the privacy commissioners. And so in that context, depending on the technology, I think it's okay for it to remain as flexible as it is so that we go along with current standards that are constantly changing. Thank you. Thank you, Madame Lapointe. Mr. Lumiere, 6 minutes. Thank you, Mr. Chair. Thank you, everyone, for your interventions today. I will start with Madame Graton. Even though the bill contains prohibition for re-identification, Article 39 allows companies to communicate personal information of an individual without their knowledge or without their consent to organizations that do not fall under the law for socially beneficial reasons. So, how can we find a balance between privacy protection and facilitating disclosure, particularly when non-regulated organizations are involved? Now, Section 39 has an exception, but it's only in one direction. It's only companies that can share with public sector organizations without protection. And in the brief that I submitted, it's something I mentioned. I said that there should be protections, even for public sector organizations. What I'm saying is that if it's good for the public sector, then it may also be good for the private sector. But we need security measures. For example, in Quebec, in some cases, there could be exchanges to assess risk factors when it comes to privacy protections. We need to submit an agreement that includes certain clauses. So I think there are ways of getting a balance, the right balance. But excluding private sector companies from this section, Section 39, is shooting ourselves in the foot because private sector companies have lots of resources, lots of ideas, have lots of data. So why exclude them? Well, let me ask you another question. What additional measures should be introduced to make sure that data is shared in a more responsible way in such a case? In English, we have a privacy pact assessment, so we assess the risk factors to determine what the risks are, how we could reduce them. There could be requirements forcing companies that want to share information to come up with that assessment and send it to the privacy commissioner, so that there will be a certain surveillance when there's data being exchanged. They could also be subject to some contracts to make sure that security measures and the minimum requirements are respected, to make sure that, well, if the privacy commissioner is informed, risk is assessed, contractual clauses are there, we make sure that the data is well identified and secured in some circumstances. And in that way, I believe we will be able to get to a right balance. In another vein, in C27, there's a problem when it comes to the Quebec regulation that was recently adopted and the Canadian regulation. As you know, Minister Champagne publicized a letter to the committee to clarify and acknowledge the fact that the Quebec law was similar to the Canadian law. So there could be precedents. So are you in agreement with that analysis? Yes, indeed. They are similar, maybe more stringent to some extent, particularly when it comes to profiling. We have at Section 8.1 this risk factor assessments, and in Quebec there are additional requirements. But clearly, it's acceptable if you were to compare the new Quebec requirements to C27. There's no doubt that Quebec will pass the test. Thank you very much. Mr. Terrien, the law proposed focuses on the need for informed consent, and there's an entire section about that. But we've realized the increase in platforms that want to use exclusion formulas instead of using inclusion. In your opinion, does this legislation do enough to protect users from platforms from this exclusion? I would say that Section 15 should be amended. In the current legislation, there's 6.1, Section 6.1, which carries some requirements when it comes to consent. Basically, this has to do with the notion that for consent to be valid, the person giving consent should be able to understand the purposes for which the information will be used and the consequences of that disclosure. This terminology doesn't exist in C27, and I think that it will be preferable that we use the old wording. In a conference, I was listening to you, and you talked about personal information. You said that this raw material is personal or private information, and I thought that that discussion could be had here. Is it really information that is public? Once you share something on Facebook, for example, a photograph or a picture or something, does that become public? In common parlance, when people put their information on social media and they allow other people to see that information, we could think that that information has become public. And that's important in this context. It's important for business corporations. Companies could use that information as public information and not private information, but the current legislation provides that information remains personal, cannot be used by companies except in accordance with the law. I think that's one good aspect of the current legislation. There is nothing in C27 that changes that situation. It's a good thing. Thank you. Thank you, Mr. Lumiere. Mr. Massé.
And maybe I'll start with the witnesses that are online. I'd like to get everybody's position on the tribunal, whether you're in favor or opposed. And a couple thoughts on that. I'll have to share time with everybody, but we'll start with our online witnesses because they often get missed at times. So please, who wants to go first? Just pick yourselves.
Okay, I'll start.
Yeah, thank you.
Is that okay?
Yes.
I'll start. So the Privacy Commissioner has been working so far as an ombudsman model, and it also has an advisory branch. That's quite useful. So this means that when there's an investigation, there's a conversation, there's a dialogue. In some cases, businesses can go knocking on their door and say, "Hey, what do you think about this business model? We want your input." I'm just concerned that if this become if there's a tribunal and it's will that relationship be impacted potentially? So I guess that's concern number one. My other concern is the fact that a lot of these privacy principles are quite flexible. And we need that in our privacy law. The notion of consent, sometimes it's expressed, sometimes it's implied. It's subject to the reasonable expectation of the individual. Security measures have to be adequate in light of the context. So there's so much gray zones, uncertainty. Now it's in the law. It's no longer principles. So then adding the tribunal, it's just perhaps a layer of risk for businesses that have to navigate with a lot of gray zones in the law. I'll keep it at
Witnesses, that. And I only have about 4 minutes left, I think. So if we can share that, would be great.
I'll just add one quick point is that reducing uncertainty is always beneficial. And to the extent that any additional requirements increase uncertainty or add additional hoops for organizations to know what they have to do generally results in some cases paralysis or important decisions not being made.
So Mr. Fraser, and across the board here. Yeah.
Sure. So starting with the assumption of having order-making powers and penalties, we do need to have an independent decision maker, in my view. That could be the tribunal, or that could be the federal court. I don't see why it couldn't be the federal court. And I'm concerned that standing up a tribunal is actually going to delay the implementation of this legislation, because that's going to take a number of years simply to hire the staff, rent the photocopiers, all those other things.
Great. Thank you, Mr. Fraser. Mr. Theron, and then we'll get to...
I'll try to be brief. The goal, I think, of these provisions should provide quick and effective remedies for citizens. In no other jurisdiction that I know of is there a tribunal such as that proposed in this legislation. In all other jurisdictions, in privacy, the original decision maker, including with the power to make orders and fines, is the Data Protection Authority, that is the equivalent of the Office of the Privacy Commissioner. I hear concerns about the difficulty for the OPC to work with different roles. That is not a problem in other jurisdictions. It is well known in law that it is possible for an administrative tribunal to have investigative, advisory, and adjudicative functions. This needs to be managed. It can be managed, and there's no problem there. I think the tribunal will create delays and will simply be duplicative of the expert work of the Office of the Privacy Commissioner. And again, there is no precedent internationally for this.
Yep. Mr. Kartash, I don't know if I have time. You can take it from my next round if I'd like to have him. Thank you, Mr. Chair.
I personally am fully in favor of the tribunal. I think it's important to start the conversation with looking at the sheer quantum of the potential penalties for contravention of the Act, which, comparatively speaking, with any other statutory framework is immense. Like with larger corporation, hundreds of millions of dollars. As Mr. Fraser mentioned in his opening remarks, it's absolutely imperative in a circumstance when you're introducing a regime with that level of penalty, it could be potentially impactful for businesses in every constituency here, that you just have a procedural fairness piece on that. And everyone agrees with that. This will add to that procedural fairness piece, and it will allow for, in my view, an appropriate articulation of whatever the penalty is or should be in a particular circumstance.
Okay. Thank you. Thank you, Mr. Chair. Thank you to the witness.
Thank you very much. I'll now turn to Mr. Williams for 5 minutes.
Thank you, Mr. Chair. Mr. Kardash, I'm going to start with you. If you can explain, I know it's all in here, but in one sentence each, what is the definition of de-identify and the definition of anonymize?
It's a good question. These are technical terms, and they often cause confusion. Canon has been established to help demystify these terminology because that ambiguity creates uncertainty. Uncertainty creates reticence risk. It's an issue. Simply put, de-identified data is just the removal of direct identifiers. The language actually is quite elegant within current language in the CPPA. And you remove direct identifiers, you still have indirect identifiers. In other words, the data is still potentially identifiable. So de-identified data is still regulated by the statutory framework. Anonymized data, which was the subject of my opening remarks, has a more exact definition where it sets the standard for the application of the statute. And the current, I think it's really important to go through this given how technical these terms are. The current definition talks about irreversible and permanent modification in accordance with generally accepted best practices to ensure that an individual cannot be identified from the information directly or indirectly. Our view is, and the view supported by our extensive consultations and jurisdictional analysis, et cetera, is that doesn't work. You need the contextual piece, reasonable foreseeable risk in the circumstances. That's embedded in Law 25. That's embedded in the PHIPA. And you'll see in the briefs we provide you these other regimes. But anonymized data where there's no foreseeable risk in the circumstances to identify the individual.
And if I understand you correctly, then you've stated that you can use de-identify as long as it complies, as you've noted here, with Section 74 of the Act, correct?
Yes. The essence is, well, it's even broader than that because I think it's important to note that de-identified information is subject to all the protections within the statute. Yes, and there has to be a recognition of, well, how do you de-identify? And I think you're referring to Section 74 with proportionality, and it has to be brought in.
And the reason I say that, there is a case study we can use, and Mr. Terry knows well about this. So in the holiday season of 2021, TELUS was selling data to the Public Health Agency of Canada. Canadians who went out during a lockdown and went and visited the pharmacy or went to the grocery store were tracked, and that data was sold to the Canadian government. We did then talk about this in ethics, and Mr. Tarian, you were very succinct in your comments. You said that two parts of this. There was not implied consent. You noted that while there was reference to data for good programs somewhere in the TELUS privacy policies, while the government does make an effort to inform citizens, I don't think anyone would seriously argue that most of the users didn't know their data was being used. And my real question is just trying to back this up. Does this act with your amendments fix that situation? I'm going to ask Mr. Kardash that first. Mr. Terry, on the question to you afterwards would be, does this act go far enough to address the consent model that we're looking for if this were to ever happen again? So Mr. Kardash, I'll start with you.
The requirements for consent in the regime apply to personal information. It could be de-identified data, which is just the removal of direct identifiers. They don't apply to personal information where right now, as currently drafted, the statute, where it's reasonably foreseeable. The Office of the Privacy Commissioner of Canada did an excellent job in that investigation. I know it well. I acted on it in that investigation. And in their careful analysis, they determined that the data that was received by the Public Health Agency of Canada was not identifiable in the context of the disclosures that took place. So therefore, if the data was not identifiable, it's not personal information. If it's not personal information, it wouldn't be subject to the consent requirements or otherwise to the statutory regime. Our surgical amendments make no difference to that. In fact, it just reflects the current law, et cetera. But again, I can't overstate. There is an exceptionally high standard for what is personal information right now. You have to look contextually at the circumstances, and you have to look at the technical methods for de-identifying wrapped in administrative controls, security controls, physical controls, and those suite of controls were implemented on top of some very sophisticated methods to ensure that the Public Health Agency of Canada, as determined by the Office of the Privacy Commissioner of Canada, did not receive any identifiable data.
And I just want to allow some time for Mr. Terry to jump in. Sorry, I only have a couple seconds left.
I would agree in large part with Mr. Kardash. When I was commissioner and we were seized with this matter, we had not seen the measures taken by the companies to anonymize the information. So in short, de-identified information is still personal information and requires consent. Does consent, do the consent provisions need to be improved in the CPPA? Yes, but that's in the scenario of de-identified information. If the information is truly anonymized, it is no longer personal, it is no longer at risk, and can be shared more freely.
Thank you.
Merci beaucoup. Monsieur Turnbull.
Thank you, Chair. What a great discussion we're having today. I really thank you all for your expert testimony. Maybe following up on Mr. Williams' sort of line of testimony or line of questioning, Mr. Kardash, I'll sort of point a couple of questions towards you. Just so I understand correctly, you've said basically that the definition currently of anonymized data is too high of a standard and it doesn't align with other statutes, and you're saying that we should essentially that the standard is already high enough within those other statutes, and we should just harmonize the CPPA with that.
Yeah.
Is that correct?
It's interoperability. So
Yep.
three very quick components. I recognize the time constraints. Number one, it's a very high standard as articulated by jurisprudence. Number two, and we cite at least 12 statutes in there for you to look offline, including Law 25 and a very rigorous regime, the Personal Health Information Protection Act, that basically incorporate this contextual requirement, reasonably foreseeable risk in the circumstances, or very, very similar wording. So it's for interoperability, which is absolutely critical. That's right.
Got that. Great. And then you had used the term expressly contextual risk, which I'm not sure I fully understand. Could you explain that a little bit further?
Yes, and I would ask that my colleague Khaled sort of supplement my comments. Sure. When you are looking at a particular record of data, you have to look at it in the context in order to make a determination. This is actually for privacy protection, doing that. Reasonably foreseeable in the circumstances is that contextual factor that needs to be articulated. And it's consistent with best practices. This is the way risk management is implemented for the purposes of this analysis. Khaled, I ask you, please supplement, because you deal with this so practically, and it would be very helpful.
I think the key point is that the anonymized data includes modifications to the data as well as the additional controls that the data user or data recipient has to put in place, additional security controls and privacy controls and contractual controls. So it's not just about the data, it's about the additional controls, and these are contextual in the sense that depending on the sensitivity of the data, you may implement more controls, for example. So it's not just about the data, it's about the data and the context around it, or the additional administrative and technical controls around it.
Thank you for that. And maybe to Ms. Graton, Mr. Terrien had actually said that the European law is the gold standard, and he talked about how there was no real inconsistency in terms of protecting privacy and the legitimate interests that you had rightly pointed out. I think you're making very specific suggestions on the different types of legitimate interests that are included currently in the CPPA. Would your suggestions actually further align us with the European law or the gold standard that Mr. Terrien had mentioned?
I think so too. In fact, when and you'll note from my brief that I'm actually proposing that the legitimate interest consent exception be more aligned with the GDPR. So.
Okay, great. Any places where you think we could or need to go further than the European law?
I think we don't need to go further than the European law. We just, I guess my other comments really have to do with making sure that we're not hampering innovation, you know.
Yeah, and I see the point that this is really about a balancing act. I think everybody has talked about that, and it's how to get that balance right. I know we started off in our last meeting with the current privacy commissioner and having that discussion as well. And we sort of got to that point at the end, as this is a delicate balancing act. I know that some members expressed points of view that may side a little bit more with, maybe weighting privacy rights and protection even more. I think we've also heard witness testimony that the two are largely aligned, that innovation and privacy rights are largely aligned in many of the cases. Mrs. Gratton, from your perspective, is there a risk that we go too far? Because I take it that a lot of your testimony is related to where we sort of draw the line and how we can facilitate a process where innovators can continue to innovate and offer the value that I think we all benefit from on a daily basis of all of the digital tools that enhance our lives. Could you just speak to that?
So when you say go too far, I'm assuming you're talking about protecting privacy too much?
I mean, stifling innovation is really what, because I'm concerned with, on both sides of this, is just getting the balance right. I obviously value my fundamental right to privacy, as all Canadians do. At the same time, I don't want to stifle innovation and the kinds of benefits that Canadians get from these digital tools.
Yeah, well, what I can say is that out of the 4 recommendations that I'm getting, 3 out of 4, I'm actually proposing that our law be more aligned with Europe, or Quebec, so which are actually more stringent. So it's also an issue with interoperability, making sure that our requirements are harmonized, especially when they make sense. We don't need to reinvent the wheel. If Quebec got it right, or in Europe they got it right through the GDPR, why reinvent the wheel? I think perhaps one issue that I'd like to raise is that in Europe, they have interpreted their requirements to website needing cookie banners. And 5 years later, they're reassessing that. There's a movement in Europe, the cookie pledge, and they're reassessing, are we protecting better, website users with these cookie banners that are extremely complex? People are just accepting them. So maybe if that one lesson learned from Europe that we should not replicate here is pushing for website cookie banners, I think.
Thank you very much, Madame Gratton, Monsieur Turnbull. Monsieur Le Maire.
Merci, Monsieur le Président.
Thank you, Chair. Mr. Kadash, according to a document published by the Canadian Anonymization Network, you have an interesting course published in 2023 in May. The current definition of anonymization sets a very high threshold that cannot be met in circumstances where information is no longer considered as anonymized. This refers to Law 25, adopted by Quebec in 2021, which uses a language that is more moderate to make sure that anonymization is doable, and proposes a similar language to ensure interoperability of the two regimes. According to you, if we maintain that language in the current legislation, what are implications for Quebec companies, more specifically small and medium-sized enterprises that will be subject to it, because Law 25 will have precedence, but will also be subject to this legislation if they cross the border?
Saying, what would be the impact if we do or we do not make our recommended change to the definition of anonymized? Sorry, I just want to clarify so I'm answering your question correctly.
Ben, je trouve votre angle est intéressant.
Your angle is interesting. Maybe you should answer with the 2 angles. What would be the case if it's applied and if it's not applied?
It is really important for companies to have legislative schemes in the privacy area which are interoperable. If you don't have interoperability, you'll create lots of confusion, lots of uncertainty. There'll be reticence risk, which is the risk of not doing anything, and just overall problems with it. All we're doing is actually incorporating a well-understood concept to ensure the term was used harmonized, interoperability sort of similar. It's really, really important to do that. I think there would be adverse consequences. If you don't put it in, there'll be an open question why. So obviously it's a different standard. And our view is there's no need for that. Privacy protection could be there. It's a very high standard right now. And we just don't need that at all. It'll be beneficial at all, especially striking the balance that we just heard from before. So that's why we're so strongly in support. I will add, we had these consultations. They were extensive. A working group spent countless hours dealing with it. We met with folks. This was universally accepted in all our discussions. Yes, let's make it clear. Let's stay with this. It's the appropriate and prudent approach to take.
Merci beaucoup. Merci.
Thank you very much. Thank you, Mr. Massey.
And apologies for me leaving often during the meeting off and on. World events particularly complicate my riding in Windsor and the Detroit region, so I apologize for that if I repeat something or miss something. But I will go back and listen to the rest of the stuff I've missed from the witnesses. To Mr. Theron, I do want to ask a question about a certain situation with the Competition Bureau was recently had to pay a fine for investigating the Shaw takeover by Rogers and opposing it, and it was ruled against them. And through other testimony, we learned that might be the same process that could happen here for the Privacy Commission in this legislation. So we have to sort that out because I was told different from one, and we had different testimony from another. Just again with the tribunal, I know you had a little more to offer. Creating this type of a body, do you really think it could undermine? I think the strength of the Privacy Commission in general. I worry about that because I know that the United States doesn't have this model, but for ourselves, I think it's actually served Canadians quite well. So I'd like to expand on the vulnerability if we change the route that we have right now.
Thank you for that. I think there is a risk of the OPC being undermined in the following way, at least. The federal office works with and has to work because data flows internationally and within provinces in Canada. The OPC works with colleagues in Canada and internationally. As I explained in my earlier answer, there is no other jurisdiction with the type of tribunal that is proposed federally under the CPPA. So that would put the OPC in a situation where when it conducts joint investigations with colleagues across Canada or internationally, its position would be less, certainly would be effective later than that of its colleagues, and it would have, the OPC would have to wait for the blessing of the tribunal for for an order to be upheld or for a penalty to be imposed. So that's one thing. But I think even more importantly, Canadian citizens would have to wait longer than others in other jurisdictions, including in Quebec. The CAI in Quebec does have order making and fine imposing powers. So there's a difference in terms of the rapidity with which Canadian citizens would have protection compared with other jurisdictions.
Okay, thank you. Thank you, Mr. Chair.
Merci beaucoup, Monsieur Vice, pour 5 minutes.
Thank you, Mr. Vice. 5 minutes.
In your expertise on this very important bill. I'm very concerned about children. If you watched my testimony in the last meeting, I'm very concerned about how a child can consent to provide any sort of data that could be used for a business interest moving forward. This is an open-ended question to anyone who wants to respond. Under socially beneficial purposes, how do we define a socially beneficial purpose? It's in the Act, 39.
The context of children.
Yes.
If we look at Section 39 and the definition of socially beneficial purposes, One of these purposes would be for disclosure to a healthcare institution, post-secondary education, or a public library. Certainly healthcare.
Thank you. I guess I'm most concerned about point 4, any other prescribed entity. What's a prescribed entity in the context of a socially beneficial purpose as it could relate to de-anonymized data from a child?
That would be a good question to the government because there's been no regulation.
Okay. Well, that sort of answers my question. Is we don't know, and what I hear from you today is we talk about consent as well, and my concern is the consent of a child. We don't have a definitive age for a minor in this legislation. Do any of you want to comment on whether we need to define the age of a child, and should there be different tiers of consent related to a minor in this legislation? And again, it all goes back to my kid on an iPad when I'm sitting on an airplane or we're driving somewhere and he's in the back and he's clicking on certain things. I don't know where that information's going, and I get scared about that. And I'm fearful as a parent, and I know every committee member around here has similar concerns that I do. How can we address that in this legislation to make sure children are protected?
I'm happy to weigh in with some thoughts because it's something I've turned my mind to. So in the legislation, it refers to minors. And minors is defined by provincial law. Minors are 18 in Alberta and 18 in Quebec and 19 everywhere else. So there's a different line. One of the challenges that I think exists with children and privacy is that there really are not easily drawn bright lines that say under this particular magic age, you are completely under the control of your parents and you have no ability to consent in a valid way. Or over this age, you're magically endowed with those particular powers. As a parent of three young men now, you can tell that at different ages there are different levels of maturity, and it's difficult to determine. The way that it actually works in practice is difficult to operationalize. That you have to take into account the individual characteristics of the young person, and are they able to, Mr. Therrien talked about the requirements for knowledgeable, informed consent. Is the child capable of understanding what it is that they're consenting to, what those consequences are? And it's actually tied pretty similarly to consent to medical treatment, and so it's not completely isolated in its own little world. But
I'm going to pass it over to Mr. Kardash just because that was a great point, Mr. Kardash.
The statute expressly sets out that minors' data is sensitive information. It's expressly contemplated in there.
Yes.
And by doing so, what ends up happening is that many of the other provisions in the statute have to look at the treatment of sensitive information. So, for instance, when you're dealing with safeguarding is appropriate, implemented, it's appropriate to the sensitivity. When you consider different requirements,
Thank
like
you.
even
So
consent,
would the provisions related to sensitive information outlined in Clause 12 override, say, Clause 38 of the bill, as it relates to the use of information for literary purposes, for example, in the context of children?
So I think once you take data and there's more sensitivity to it, there'll be a holistic set of provisions in the Act that will be applied. Even currently, the case right now with Section 5.3 in the statute, and it's amended now, it's even more involved. Organizations are only allowed to collect, use, and disclose personal information that a reasonable person would consider appropriate. Now, that might seem broad, but that's privacy protective in nature, because the more sensitive the data, that will impact your statutory analysis of what a reasonable person would consider appropriate in the circumstances.
Thank you. Do we need to define a child in this legislation?
I don't think so. Under the age of minors under the age of 13, they wouldn't have the capacity to consent, etc. That would be protected. Data would be protected otherwise. There is an idea about specifying under the age of 18. I think it works right now. I don't think you have to do it. The key thing in the statute, which goes to the heart of your concern, I think the concern of everyone in the room, certainly myself, is the protection of minors, very important, but there's express contemplation already in the statutory framework that it is sensitive data, and that has a flow-through impact, and it would be treated well, certainly from a statutory interpretation perspective.
Do you believe we need to do more to amend Section 12 to be 100% sure that the rights of children, when we define a fundamental right to privacy, are given the attention it deserves? Mr. Therrien.
The Minister Champagne has tabled amendments to the preamble and to Section 12 that would provide greater protection to children. Again, that is a step in the right direction. But I'm concerned that the terminology used may be too limitative, and that is why I have recommended in the text I have provided with you that Section 12 be amended to refer to the concept of the best interest of the child. That concept has to be interpreted contextually. It is not limited, although again, the language proposed is a step in the right direction, but it may be too limited, and I think the concept of best interest of the child would provide fuller protection.
Thank you. That's very helpful. Merci beaucoup, Monsieur Gaillard.
Great, thank you, Chair. And I just want to say thank you to the witnesses for appearing for the committee and for their useful testimony. My questions are actually playing off of what Mr. Viss said. I wanted to talk about socially beneficial purpose as well. My questions are for Mr. Kardash. We know that according to Section 39 of the CPPA, an organization has the right to disclose de-identified information, personal information, without the knowledge of the individual or the consent of the individual, certain entities, if the disclosure is made for a socially beneficial purpose. And that is defined in the Act. It means like related to health, provision or improvement of public amenities or infrastructure, the protection of the environment, or a prescribed purpose. Do you think that this definition of socially beneficial purpose is enough to protect the privacy interests of Canadians, in addition to the fact that this is already de-identified information, which you said in your testimony, in your opening testimony, it's already it's a very high bar, it's an exacting standard?
So this provision was the subject of extensive discussion in Canon's consultations, and in our brief, which was submitted to INDU, you'll see some specific provisions that we are suggesting to enhance the privacy protection with respect to the personal information that would be subject to these disclosures. Eloise Greton mentioned elements of these. We indicated that in addition to the personal information being de-identified, notification to the Office of the Privacy Commissioner of Canada, and entering into a specific agreement that binds the recipient. And then we add, to ensure that we stay temporal with this and current, we add a prescribed organization complies with any other prescribed requirement. So it gives the opportunity of the government to reassess and then introduce regulations to even further add more requirements for perhaps the recipient of the data or the disclosing entity. So we think disclosure for socially beneficial purposes is excellent because of the good that it is, data for good, but we do strongly believe, and we've made specific recommendations, that there should be additional privacy protections implemented with respect to that provision. That helps strike that balance.
So when I hear that testimony, you said de-identified already. It's a pretty high standard. It's an exacting standard, and you actually want to lower that bar. But then for information that's de-identified and then also has to serve a socially beneficial purpose, do you feel like that sort of strikes that balance already, or would you go even further?
Our sense, again, this is based on just the extensive consultations, is that as drafted, and again, taking into account that you can't just look at any exception to consent in a vacuum. Even all those disclosures, if you were relying on an exception to consent disclosures, are subject to many statutory provisions in the Act. But with respect to this provision, we believe that if you enhance the privacy protections with our suggested amendments, and as also mentioned by other witnesses in today's hearing, together with a prescribed requirement for additional protections over time to be introduced by the government if it so feels that it's necessary to do so, that would strike the necessary balance. Data for good is something that could be extraordinarily helpful. There's a wealth, even unknown benefits to all Canadians. And when we saw this provision initially, there was broad-based support. But we fully recognized some of the concerns, and we addressed them with our suggested revisions. We think it's a good balance with our suggested revisions.
Great, thank you. I do support your proposals. I just wanted the testimony to come out. My other question is regarding disclosure of personal information without the knowledge or consent of the individual if it's made for a business activity. And that definition is also given where, A, a reasonable person would expect such collection or use of that activity, and B, that the personal information is not collected or used for the purpose of influencing that individual's behavior. What do you think about this definition and that sort of, and how it's being narrowed?
Welcome others' comments. My sense is the government did an excellent job with articulating some circumstances where it's expected that organizations would be using the data. These are not particularly controversial types of uses. Again, it's just exceptions to consent. It doesn't mean you're not subject to all the other requirements as applicable in the circumstances, and I think that's something that's often overlooked in discussion. Our review, our careful review of that, is that those were welcomed, and the government did an excellent job with them.
Great, thank you.
Merci beaucoup, Monsieur Généreux.
Thank you very much, Mr. Généreux. Thank you, Mr. Chair. Thank you, witnesses. Mr. Terrien, you were here when C11 was tabled. You proposed amendments, but you said that the bill was a step back when compared to what existed at that time. Your successor proposed 15 amendments. You were in agreement with those amendments. The government retained only 5 of them. Out of the 10 others that were not retained by the government, which, in your opinion, will be fundamental to be implemented, should be included in the current bill, out of the 10 that the government failed to retain? I think they're all important. I pointed out others in my text myself, particularly talking about proactive audit. If I were to choose, I will say that we come up with the obligation for a risk assessment. That should be a legal requirement. That should be part of the priorities, in my opinion. Furthermore, something that is less discussed is that in the current bill, as currently proposed, organizations will have great latitude in defining the purposes for which they can use information. Commissioner Dufresne and myself, when I was commissioner, we are recommending that the purposes for which information could be used should be explicit and precise. Those words are important. This would align with the European legislation. This is one way of making sure that there's greater balance between the tools given to companies, which can once again define purposes as they will, and a more direct definition of those purposes. A while ago, Mr. Fraser said that, in his opinion, there should be an external tribunal and not an internal one. What is the fundamental difference? We understand that we have 2 visions. What Mr. Fraser wants something that is external. I think Mr. Terrien wants it to be internal. To be judge and jury, is there no risk that a lot of power may be given to commissioners? Maybe not so. At the same time, the commissioner is promoting privacy rights and the consequences of the bill of the legislation if privacy is violated. Is there no potential conflict of interest? That's a possibility. I would rather not talk of risk. It's possible that the legislation, as a matter of routine, provide for that. There are many administrative tribunals. So the commissioner could have those powers without us having a tribunal, without being lawyer and adjudicator. Those powers should clearly be separated within the organization. And the final result, for example, an order taken by the Office of the Commissioner should be the subject of legal controls to make sure that the procedure was fair towards the companies. But such potential conflicts are often managed by administration tribunals without any problem. Mr. Fraser?
It's two different models. We also do have, for example, a Human Rights Commission and a Human Rights Tribunal, a competition commissioner and a competition tribunal. So there are other scenarios in Canada in which that particular model is applicable. And there is the possibility, and one would have to have controls and procedural safeguards within the Office of the Privacy Commission of Canada to make sure that those conflicts did not arise. I think that given the stakes that this legislation presents with multi-million-dollar penalties and even multi-billion-dollar penalties when you look at percentages of a company's global turnover, that not only that raises the requirement for additional procedural safeguards. You can think of it as a scenario in which a police officer can write a ticket and you can just pay the ticket and plead guilty and go on your way, or you can dispute it, and the police officer has the burden of proving in front of an impartial decision maker whether or not the facts alleged in that ticket are made out. And that would be the model that I would advocate for. Or maybe we can split the difference, and when it comes to anything that has a significant penalty over a certain threshold would require those additional safeguards. But those are going to be important. And I would also note, with respect to the new advent or we're seeing more and more multi-jurisdictional investigations taking place simultaneously, organizations are going to be subject to multiple penalties in multiple places arising from the exact same investigation, kind of multiplying that across. So the fine threshold in Quebec is pretty similar to the fine threshold here, and so you can find those being doubly leveled, which again, at least to me, raises the stakes higher.
Je veux pas que vous vous battiez, là, mais M. Terrien.
Mr. Terrien, what do you think about that?
Pour ce qui est du montant.
Talking about the amount of the penalties, clearly the penalties provided for in the law are extremely high. But it's the case in Europe, it's the case in other administrations, it's the case in Quebec with Law 25. And in all these models, without any exception, the first instance court, equivalent of the OPC, is able to make those decisions. I think there's a danger, as I just told Mr. Massey, that if the federal commissioner doesn't have the same tools as their colleagues, this could create significant complexities when they're dealing with other jurisdictions. Thank you very much.
The floor to MP Van Bynen.
I'm wondering if this legislation reflects the current state that we're in. Example, if we were 10 years back, would the legislation that we're proposing now, would we be in a different situation? And I'm thinking of Facebook, I'm thinking of GBT, I'm thinking of social media. For anyone who doesn't think that their privacy is already has an intrusion, either doesn't have a cell phone or a social media account, how can we change that? Or is the intent to control that? And how can we best do that? And I'll start with Mr. Fraser.
Well, I guess I would start with wondering whether you think that we should have a world without Facebook and ChatGPT and things like that. In my view, this legislation takes what we have existing in PIPEDA largely, and as I said, turns it up to 11. So it puts a greater requirement of diligence on the part of organizations in order to, for example, justify their decision-making, document risks, and do those sorts of things, and then has those substantial penalties. Mm-hmm. So had this been implemented 10 years ago, I'm not sure the universe would be all that different, because I think it's still based on the 10 principles from the Canadian Standards Association Model Code for the Protection of Personal Information, which are very Canadian principles with respect to privacy. Although I am very curious to hear from Mr. Terrien in terms of how he thinks it would have been different had he entered office with CPPA at his disposal.
Mm-hmm. Mr. Terrien.
I think the CPPA brings us much closer to where we ought to be in 2023. And with the new advent or the new implementation of artificial intelligence, Part 2 of Bill C-27 is an attempt to align Canada's legislation to that new technology. Now, there's no perfect solution in all of these situations. There are people who think that see that the Artificial Intelligence Act is so skeletal as to be meaningless, and there's some merit to this. I think it's okay for where we are today. I think one virtue of the legislation that is before you is that it continues with the consent model in many circumstances where consent can possibly be given, but it also recognizes that there are important limits to the consent model, hence legitimate interests and socially beneficial purposes. But I think the missing piece is that these additional flexibilities that reflect current use of technology have to be implemented within a rights protection framework. And although the minister's latest amendments bring us a bit closer, we are still quite a ways from where we ought to be, and that's why I recommended that Section 12 and 94 on penalties, particularly penalties, are important, because what's the value of having a recognition of privacy as a fundamental right if there is no penalty when you breach that principle?
Do you think that what we're introducing now is going to change the behavior and uses of data that's currently in the hands of some of these organizations?
We hope that with time, with not only penalties, but including penalties, but it starts with companies acting responsibly, regulators working with businesses to ensure that the law is actually being implemented. So there are advisory roles to the OPC that are important, but also with penalties, that the right set of incentives will be there for behavior to change.
Mm-hmm. Okay, and then this comes back to your suggestion that there should be proactive audits by the Privacy Commissioner to ensure that whatever additional responsibilities is being created through this legislation is being adhered to.
In brief, my point there is that it is extremely difficult, if not impossible, for individual consumers to understand how their data is used. It is even difficult for the regulator to understand how data is used. How will violations be identified if we rely mostly on individual consumers to make complaints? There are provisions, I know, for commissioner-initiated complaints, but the model we have is premised mostly on the basis that individual consumers will complain. In many situations, they don't know that there's a violation. So proactive audits exist in other jurisdictions that I've mentioned in my document, whereby the regulator can audit the practices of a company, not because there's belief that there's been a violation already, but simply to reassure consumers that this new practice actually does comply with the law, and therefore, yes, you can have confidence that it is privacy protected, or know that it is not, and then the company will have to amend its practices. So I think proactivity is extremely important.
Any more time?
Merci beaucoup, Monsieur Van Bynen. Monsieur Lemire.
Mr. Lemire. Thank you, Mr. Chair. Mr. Terrien, talking about Section 4.1, the rights of children to seek recourse, not only through their parents, could we go further by recognizing the Convention on the Rights of the Children regarding the rights of children and giving children the right to participate and be heard directly or indirectly in all procedures that interest them without necessarily going through someone. According to Canada's constitution, when it comes to shared powers, when I recommend that Section 12 be amended to refer to the superior interests of the child, I'm thinking of the International Convention on the Rights of Children. Now, what procedural rights should we give children within the framework of the various procedures? Is this something that could be done by federal law, or does this fall under provincial law? I will not take a stand on that. Does someone want to say something about that? Madame Graton. You are mute. You are muted. The discussion has evolved. What was the question? I was asking whether we should recognize the right of a child to seek remedy, access to recourse and to complaints procedure, the right to be heard if children have suffered abuse or any prejudice. Mr. Terre hesitates to take a stand because there's shared jurisdiction. Some are provincial. In Quebec, we have a civil code that frames the right of children. I don't think that we need to go any further than seeking protection of the data of children by organizations, and that is the purpose of this legislation. We talked earlier about age, the age of consent. I think the bill could be more precise in some regards when talking about the type of consent that a child can provide depending on the age. In Quebec, we give that, there's that distinction. But in the rest of the world, sometimes we say there's the age of majority, and then there's the age of children, which is usually between 13 to 18 and 19. In Quebec, it's 14. That creates lots of operational problems for organizations that want to implement protections for children. So we need to bear that in mind. Thank you very much. Thank you, Mr. Massey.
Mr. Chair, I want to touch something that we don't get a lot of questions from this side going this way, but I think it's important for you to, Mr. Theron, to highlight this. As R10, you have a political parties. Privacy laws apply to political parties in several jurisdictions, including Europe, British Columbia, and now Quebec. The same should be true federally. I'd like you to expand on that that point. I think it's something that we don't seem to get a lot of questions from this side of the table going that way on it, but I think it is important to consider that as a potential.
Again, so operability was mentioned previously. There are laws in many other jurisdictions, Europe, and within Canada, British Columbia, and now Quebec, that provide that privacy laws actually do apply to political parties. That is a recognition of the fact that information held by political parties is almost always sensitive information. It goes to the political views of political parties, and normally under privacy law, sensitive information is entitled to greater protection. Right now, we have no protection except what federally, except what political parties choose to put in their own privacy policies without any legal requirements. So I think it would be a very good thing for political parties to be subject to privacy laws. For instance, the CPPA, it could be possible to add a provision that would extend the CPPA to political parties, recognizing the sensitive nature of that information.
Great. Mr. Kardash had whatever time is left.
I'll be brief. My view, and we've thought about this quite carefully, is there is no public policy rationale for the political parties processing of personal information not being subject to a privacy legislative regime. The only question I think is open is what would be the appropriate instrument, whether that would go into the CPPA. I think there's some validity to the proposition that it might be a separate instrument. In my personal view, that was something that was devoid in C27. It could have been in there. Right now, if you compare the privacy protections that are set out in C27 under the CPPA and compare it to what is the current protections afforded to individuals with respect to the processing of personal information of political parties, it's not even in the same universe. You would just have to post a privacy statement. There's no security breach notification requirement, no access rights, there's no consent rules, and it goes on and on and on. No rights of express redress. There's no independent ombudsman that would oversee and take complaints and investigate, et cetera. So I think this is something incredibly important, and I'm very thankful, Mr. Massey, for you bringing that up.
Okay, thank you. Thank you. Thank you, Mr. Chair.
So thank you, Mr. Massey. I'll now turn the floor to Mr. Perkins.
Thank you, Mr. Chair. This has been a very interesting testimony. Mr. Tirian, I'd just like to follow up on MP Vis's questions initially, just from the start, on the issue of minor. The only place in the bill that minor is mentioned is in the interpretation section at the beginning. It doesn't define a minor, and I think a lot of us are in agreement this bill should define an age of the minor. But it also says that this act, the personal information of minors, is considered to be sensitive information. But for the life of me, when I look through this act, I don't see any definition of what sensitive information is.
The concept of sensitive information is currently undefined under the current law and would be under the proposed law, which normally leads to what is called a contextual application of what is sensitive. So what kind of information is at play? Is it financial? Does it concern children? Does it concern health? That would be generally sensitive information under interpretation, but there's no definition in the law itself. Is it a flaw that there's no definition? At the end of the day, the definition will always be contextual. I think it is possible, though, to have a definition which would be non-exhaustive, which would refer to certain factors, financial, health, children, etc., a non-exhaustive list of factors that would define this is normally sensitive information, leaving an out clause, a residual clause, for what is not defined. I think that would be an improvement.
As a person who spent most of my career as a marketer, I love data, and I would go to the edge as much as possible that I was aware of and what I could do with that data. But I tell you, this bill and those aspects would make me nervous because I just don't see as a marketer any guidelines that help me figure that out, and I suspect most marketers would push the envelope as they do, and that may end up in trouble for their company. So I appreciate that there should be more definition. I'd like to go back to my earlier question. Mr. Tirian, Section 15.5 outlines that implied consent is okay. Personally, I don't think implied consent is ever okay, but do you see that as an issue in this bill, that implied consent is allowed?
Implied consent is certainly open to broad interpretation and sometimes abuse, but it is a concept that exists under most, if not all, privacy laws that I know of. It is a recognition of the fact that certainly in today's technological environment, you cannot ask realistically people to consent explicitly to every use of information that will be made. On the issue of what amendments to make to the consent regime, I would maintain my recommendation to align the language of Section 15, not sub 5, but another provision, to the current Section 6.1 of PIPEDA.
But the problem with the Section 15.5, which also ties to 15.6, which also ties to 18.1 and 2, is that the implied consent is allowed on a wide variety of things, including any other prescribed activity, whatever that is. It leaves it wide open. And earlier in the bill, it says if there is in the consent section, it says if there is a express consent is required, and if there is a new provision or a new use of that person's data, that express consent needs to be given again. So it seems to me that this is contradictory, saying, well, I can apply it anyway, and I don't have to pay attention to the earlier part of the bill that says I actually have to get express consent for a new purpose, except when I look at 15.5, 6, and 18.1 and 2.
My answer to that would be pay attention to the provisions that define purposes for which businesses can use information. Right now, I think it is open-ended. There are not many, if any, limitations, except Section 12. If the provisions that define original purposes or new purposes were to say only specific and explicit purposes are lawful, then I think that would be a step forward.
One last question. Who should own a person's data, me or the organization?
That's the $6 million question, certainly currently. It goes to the history of technology and legislation, the fact that many decades ago, the consent model was seen to be the best model, which assumes a lot of control. I think we've not left that world. There is still value in people controlling their information to the extent possible, but we know realistically that we're no longer in that world. And it is simply not realistic to think that citizens can provide consent in each and every case where information is used. So we need to accommodate for a world where consent is not required, but I maintain within a model that protects privacy as a fundamental right, including the 4 provisions that I mentioned earlier.
Thank you, Mr. Terrien. Mr. Sorbara.
Thank you and good afternoon, gentlemen. I apologize for missing your early testimony from a pre-existing appointment. Adam, you made a comment earlier on about the bar on personal data when I may have forgotten the words exactly in terms of how we identify personal data as being owned by the individual and not owned by the individual, identifying it. Can you elaborate on that point? If it wasn't you, I do apologize, but there wasn't a reference to that.
I think it might have been in reference when we were talking about the current bar of when data is identifiable or no longer identifiable. Yes. Right. Yes. So the current, first of all, the concept of personal information, or more specifically identifiability, is well established in Canadian jurisprudence. And unless there is a serious risk of possibility of identifying an individual directly or indirectly or just contextually, then it will be deemed to be identifiable. That is a very high bar, just given the environment, especially contextually as more dynamic data and more data, et cetera. So that's what I was speaking to. So the injection of our proposed amendment was just to align the current definition of anonymized in the CPPA to ensure that we're consistent with the jurisprudence and consistent and interoperable with the statutory regimes across the country.
As a non-lawyer,
yes,
is the bar too high, too low, or
very simply, the bar set out in the current text of the CPPA is too high. It's practically unworkable. With a simple surgical amendment, as recommended by Canon and others, by Canon, then it would address it, and it would address it in a way that's totally consistent with other legislative regimes.
Okay. C-27, in my humble view, is I'm going to use the word groundbreaking piece of legislation, but I think it is groundbreaking in terms of the update it's providing to the Act and to privacy. To Mr. Terrien, you're fully versed on privacy issues relating to Canadians. When I think of this bill and I think of my constituents back in the city of Vaughan, in my riding of Vaughan Woodbridge, and I would tell them, how is their privacy being protected or not being protected in a very sort of granular basis, layman's terms I would use it, what would you tell me to tell them in terms of your view of C-27?
You may be referring to whether the law should be principles-based or rules-based, for instance.
If I could just interject,
yeah.
yes, please, because as a finance person, as someone extensive accounting and finance background, principles-based and rules-based matter. So yes, please.
So I think at the risk, it's a bit of both. Currently, PIPEDA is principles-based. Rules are few. There are some rules, but rules are few. CPPA would certainly keep principles, but adopt many more rules. I think an effective system has both principles and rules that are at a sufficient level of generality that they can still be relevant, even if the technology or the business context changes over time. And I think where I would disagree with my colleague, Mr. Fraser, is that PIPEDA lacked the rules that would ensure protection. I'm not suggesting a prescriptive statute. I'm suggesting a statute that has both principles and actual rules stated at the right level of generality.
Okay. And a final question, if I can. When producing legislation or enacting legislation, we obviously want the legislation to be robust to handle evolving technologies, in this case, evolving situations. Where we are today is vastly different where we were 10 years ago in privacy and AI and just the technologies. The legislation that we have in front of us, in my view, has that robustness, but obviously you folks are much more inclined to be experts on this front. How would you characterize the robustness in this legislation to handle the evolving environment we're in? Mr. Kardash, and then we can go across if we have time, quickly.
The legislation is drafted in a technologically neutral and sectorally agnostic way, so that will serve Canadians well and organizations trying to comply with it, because it will allow for the evolution of practices over time to deal with that. So I think that's really helpful. And I also think that while it's often referred to as a consent-based regime, fundamentally it's an accountability-based regime. And that accountability model, and this is where I think I can't speak for my other colleagues, but I think there's broad-based agreement that Canada has led the way, actually, internationally with this accountability model. It's been adopted otherwise, and now it's been strengthened. So you have a combination of the accountability model with some careful drafting, with some enhancements to privacy protections that I think will serve organizations and, in particular, Canadians well.
I'm not sure if we have time, but if Mr. Fraser, Mr. Therion would like to land on that, or
I think it will ultimately prove to be a resilient piece of legislation. I don't see potholes or anything else like that or pitfalls in it where we're going to have to come back and revisit it in 5 or 10 years' time necessarily.
Thank you. Thank you, Chair.
Thank you, Mr. Sorbara. And we have 5 more minutes, so I'm willing to open the floor, and I'll just yield the floor to me first with consent. Maybe you won't like the question I'm about to ask, but if we were to include political parties in the Act, what would be the lowest hanging fruit that could be included in the most important one? Mr. Therion, Mr. Kardash.
Je pense il y aurait des règles sur la divulgation.
There should be regulations on disclosure by political parties. The worst case we could envisage is that of Cambridge Analytica, where some practices seeking to influence voting took place. And if political parties were subject to the privacy legislation, if such practices were to continue, at least there would have been sanctions against such types of practices. There would be a wide range of consequences information will be protected, security, safeguards. Right now, these issues are subject to voluntary decisions by political parties. If political parties were subject to the law, there will be legal consequences if information was not properly protected.
Rights of redress to the Office of the Privacy Commissioner of Canada, security breach notification requirements, rights of access, so individuals have an understanding of the personal information in the custody and control. And I would say that, and I think I missed the beginning remarks from Mr. Therrien, I think there's the wave of other fair information practices that are encapsulated within the statutory regime. Again, I just don't think it can be overstated. This is something that's really missing, and from a broader discourse, we're all focusing. The digital charter rightfully focuses on trust, and in order to establish trust, we need all participants to be subject to the same rules, etc. And I think political parties should be subject to those rules as well.
Thank you very much. This concludes my questions. We still have 4 minutes, so I recognize Mr. Lemire and then Mr. Perkins.
Merci, Monsieur le Président.
Thank you, Mr. Chair. I would like to hear you, Mr. Therrien, talk about the standards for self-regulation in the industry in the context of C27 and artificial intelligence. It's as if there's a new process in Europe, and even as Mr. Champagne said, it may be an interim measure. Could we trust industry to self-regulate? Clearly, over the past 20 years, we've seen that there were significant limitations on the self-regulation regime. That is why it is necessary for the law to be amended right now and to provide for sanctions when it comes to artificial intelligence. Once again, this is a technology whose applications are gaining ground. It will be a mistake to try to very quickly regulate it in a more precise manner. I will not only rely on self-regulation, but I don't believe that Mr. Champagne can do it. He's talking about self-regulation as a temporary measure while waiting for the legislation and other regulations to come. So I think it takes this entire legal architecture, a law, regulations, as well as codes of practice by industry to make sure that we have the best protections. But self-regulation alone is not enough. Thank you, Mr. Chair. Thank you, Mr. Perkins. Briefly.
I had two, but I'll start with one. Section 35 says an organization may disclose an individual's personal information without their knowledge or consent if collected for statistical purposes or research. It doesn't identify by whom, but it seems to me to be a fairly open-ended breach of consent, being that I can give it to the government for statistical reasons, I can give it to a university for statistical reasons or research reasons without going back, and it's personal information. Could you comment on that, Mr. Therrien, Mr. Fraser?
There's already provisions that are similar to that, but with more safeguards in PIPED and other statutes that would require a privacy impact assessment or research ethics approval or reporting to the Privacy Commissioner. There's also provisions in the Statistics Act that allow Statistics Canada to compel that sort of information. I share your concern when it comes to something that's so open-ended. One of the things that I think is a hallmark of good privacy accountability is an analysis and a determination what are the privacy risks inherent in this and what are the mitigation steps that we can take. One thing that I would just also note is that so many of those provisions are discretionary. They don't require the organization to disclose it, but permit it to do so.
Mr. Therrien?
I would extend your question to a discussion that occurred a few minutes ago. I think here we're into the use of data for the social good. It's an example of use of data for social good. And I think it is as Mr. Fraser said, there are similar provisions in the current Act. I think these are good provisions, provided that we really deal with the social good. Section 39 otherwise defines socially beneficial purposes. My colleagues, some of them have remarked that the socially beneficial purposes are limited to disclosure to public entities, and they make the point that private sector entities should be able to benefit from this. It's not inconceivable, but we need to be careful to disclose information to business for socially beneficial purposes.
It doesn't say that in Section 35. It doesn't say there's no
39,
fences around.
39 does. That's why I expanded your question to deal with social good, including 35 statistical purposes, 39 socially beneficial purposes. So I would say legitimate interests are the true domain of corporations. I think that's a latitude that is given to companies that can be defensible. Socially beneficial purposes are currently limited to public entities with the possibility of prescribing by regulations other entities, which I assume means potentially...
But that doesn't say that in 35. 35 is open to anybody.
Yes.
It's any organization. It doesn't restrict it to social good. It doesn't have any restrictions whatsoever. It just says that an organization, if they decide it, can breach your personal information and do it without consent and provide it to other people for statistical purposes or research purposes. To anybody. It doesn't say to business, doesn't say to universities, doesn't say to the government. It's available to anybody under this.
But this has been interpreted so far as essentially in the domain of public interest statistical purposes as opposed to purely commercial.
But businesses do research.
I understand.
Biotech firms do research.
I understand.
So...
Thank you very much. Ça conclut tout le temps qu'on avait pour cette rencontre. Merci.
That was all the time we had for this meeting. Thank you very much, dear colleagues. We had very interesting discussions. Thank you, witnesses, for taking time to come to see us. Thanks to the technicians, interpreters, and analysts. Meeting adjourned.